Good evening, everyone. My name is Satya Prasoon. I am an assistant professor at Nalsar University of Law. I welcome you all to the final and the concluding session of the conference. I welcome all the presenters to whose abstracts I have the chance to read, and they are all coming from very riveting and different angles. So I'm thinking that this final session is an apt conclusion to understand the construct of identity and its application to disadvantaged and marginalized identities in the Indian public realm. The common thread, although these papers can stand on their own or can stand on their own limbs independently, but the common thread running through it that they speak about marginalized identities, some ascriptive, some historically marginalized, some systematically marginalized, who have been at the receiving end of the power discourse. So we have 6 presenters who are coming from different vantages and are important stakeholders. One of whom is an academic, one is a practitioner, one is a policy shaper, one is a doctoral student, and one recent graduate and one currently undergraduate student from Nalsar. So I'll quickly lay down the themes of the paper. 2 papers deal with the question of tribal identity and the application or the misconstruction of understanding this tribal identity through Indian laws. One is a dignity affirming exploration, and another one critiques the non-identification of tribal identity through a dignity stripping perspective. Uh, One paper will interrogate this structural indignity framework heaped on people with cognitive disabilities and their consequent erasure from right to political participation. From marginalized and ascriptive identities, we will then segue into the construction of labor identity, where there is non-recognition of right to disconnect in labor laws and the implication it has for dignity discourse. Then the next presenter will speak about the stereotypical and the prejudicial effect of oral observation by judges from the bench, and what role, how is it that we can capture, or what does it say about our legal culture when these observations, which don't register themselves in form of judgments, these have uh, these have a discriminatory and indignified impact on the litigants. So that is an interesting paper that will speak about uh, the non-registration of some of these judicial practices, and how can we capture that in the dignity discourse. Uh, and after that, we will conclude by a presentation that looks at philosophical roots of dignity. I think it can be seen in succession to Professor Preetham's paper, where he's trying to locate dignity. So this paper also tries to understand the philosophical roots of dignity and tries to map the decisions of the Indian court to one of these schools. Now, there is a slight change in the format for these sessions, as the papers can stand independently. So each presenter will be given 15 minutes to present, with 5 minutes for question and answer. So with that, we'll start with the presentations. We'll start first with presentation by Assistant Professor Ezekiel Jarain, who is an assistant professor at the Faculty of Law, Delhi University. Then we'll move to 2 online presentations, one by Abhisha Isaac from Isaac Chambers Law Firm. The next one will be by Mr. Shashank Pandey, who is a research fellow at Vidhi Center for Legal Policy. And next, we will have our own Nalsar student, Shetrangna, who will be presenting on tribal identity, and Robin Jaswal, who is a doctoral student at Nalsar. And the final presentation will be by Mr. Abhineet Maurya, who is a recent graduate of NLU Delhi. So with that, I invite Professor Ezekiel to start with his presentation. 15 minutes is the time for the presentation.
A very good afternoon to everyone. It's a privilege for me to be here. It's my first time, and hopefully it's not to be the last time. It depends on how you rate me as a presenter. Okay. Well, my topic is a very long title. Maybe I can summarize. I mean, I can make it a little shorter later, but the significance of coexistence of customary and state laws in upholding the dignity of tribal people. A brief study of the justice system under the 6th schedule in Meghalaya. I just want to begin by mentioning a brief facts about Meghalaya. Okay, one of the 8 states. Meghalaya is the abode of clouds. Yeah. Let me just use here. I think that's I could see it. Yeah, one of the 8 states of the Northeast. That it means the abode of cloud. It means that's Meghalaya. A few facts about Meghalaya before I touched on the points that I will cover. Meghalaya was, of course, became a state in 1971. The entire state actually falls under the 6th schedule. That is the topic on which I'll be touching on, linking with the dignity of tribal people in Meghalaya specifically. It has 12 administrative units, districts, which in these administrative districts, you have regular courts, since I'll be touching on the judicial system. So I thought I should make it clear to you that there are, like, say, 2 sets of judicial system. We have the regular courts, where the Code of Civil Procedure, CPC, and BNSS are, of course, being followed. But then you have also the other sets of judicial system that falls under the precisely under the 6th schedule. So from the point of view of the 6th schedule, the state is being divided into 3 autonomous districts. Okay? So you have 12 administrative districts with regular courts, and then you have 3 autonomous districts with its own judicial system, where CPC and BNSS are not followed strictly, but in spirit. Okay, they have their own rules of administration. Anyway, the points that I'll cover here is, of course, just a few pointers about the 6th schedule of the Constitution is an instrument to protect the tribal identity. And of course, I will try to link this with, of course, with dignity. A brief study of the judicial system as outlined under the 6th schedule, with a focus in the courts in Meghalaya. Analysis of a case decided by a district council court, which is the apex court in the judicial system or under the 6th schedule. And then, of course, through this, my point is to highlight the importance of the coexistence of customary and state laws for the tribal people of Meghalaya, a judicial system that takes into consideration the tribal ways of life helps to protect their social identity. I would like to refer to the brief discussions, debates relating to the. So when the Constituent Assembly was debating on the 6th schedule, Dr. Ambedkar, I'd just like to highlight here, let's say, one of the reasons as to why he supported the idea that some level of autonomy should be granted to the people, to the tribal people in the Northeast. Basically saying that, okay, their laws of inheritance, their laws of marriage, customs, and so on are quite different from those of the Hindus, saying that, referring to the, precisely to the, let's say, to the Assamese, rather the non-tribals who are mostly, let's say, are following the Hindu religions. Reverend J.J.M. Nichols Roy, one of the members of the Northeast Frontier, basically the subcommittee for drafting of the subcommittee under the fundamental rights, which during again this for the drafting of the constitution, he made this observation as to why some level of autonomy should be granted. He says that it will create, of course, a feeling of friendliness and unity, that certain measure of self-government should be granted so that they may develop themselves according to their own genius and culture. Anyway, we have then, of course, the constitutional provisions, Article 244, Clause 2, which says that the provisions of the sixth schedule shall apply to the administration of the tribal areas in the states of Assam, Meghalaya, forgot the comma, okay, Tripura, and Mizoram. Okay. So the sixth schedule applies basically to these 4 states. Now, the sixth schedule, Para 3, talks about the legislative powers that are being granted on. So I mentioned at the beginning that there are 3. I'll of course restrict myself to Meghalaya. Meghalaya has 3 autonomous districts. Each autonomous district has a district council, which is a legislative body, which enacts laws, and this is precisely Para 3 of the sixth schedule, and talks about the legislative power of the district council, that it can make laws on these subjects like allotment of land, succession, inheritance, etc. Para 4 specifically talks about the administration of justice, which wherein it's here then that I mentioned at the beginning again that courts constituted under the sixth schedule, they have exclusive jurisdictions in disputes, or rather in cases between tribals, which I will elaborate later. Judicial system under sixth schedule with a focus on the courts in Meghalaya. So I'm here now coming to the basic structure, explanation about the judicial system within the sixth schedule. So basically they are being structured into 3 levels. You have the village courts, then you have the subordinate district council courts, and then of course at the top you have the district council court. A case of a decision of which I'll be discussing in highlighting this aspect as to how the coexistence between customary and state laws actually helps in upholding the protecting the dignity of the tribal people. Well, I have just simply here put in a few cases that was dealt with by the Supreme Court in interpretation, clarifications of the jurisdiction of the district council courts, which basically the bottom line is that in any disputes in any here both civil and criminal, okay, where let's say that between a dispute, a legal dispute between 2 tribals, let's say in Khasi Hills, one of the districts, in the Khasi Hills autonomous districts, it's the either the district council court or the subordinate court, of course, of the courts under the sixth schedule, which will have jurisdiction to actually entertain that that case, and not the regular courts, where I had mentioned that the regular courts, meaning that CPC and CRPC are being followed. But in these courts, the CPC and CRPC, BNSS, okay, are not being followed strictly, but then they are being followed, let's say, in terms of spirits. The procedures. So just to have a little better clarification as to then which procedural law is actually governing these court system. So we have here again as a sample. So we have the Khasi, of course, Khasi Hills autonomous districts. Sorry, I missed the hills. Okay, Khasi Hills. Okay, and then you have the Garo Hills and then the Jantia Hills. I'm just taking here the procedural law which is applicable to the Khasi Hills, which more or less they are similar, but practically the same as those of the other autonomous districts. So it's this particular rules which is being framed by the district council, which is the legislative body that actually that is applicable in the court procedures of these courts. So I have mentioned just these two provisions, Rule 43 and 47. They say that in criminal and civil cases, procedure of these courts basically constituted under the schedule, shall be in spirit of BNSS, RPC earlier, and CPC. And further, it says that in all civil matters before these courts, adjudication was to be done per law, justice, equity, and good conscience. Though formally, of course, these procedures, I'm talking about the CPC and BNSS, are not being followed strictly. But in my recent survey, in my recent research, talking to senior advocates of 10 years plus of experience of litigations, when I put one of the questions as to what is the extent that these procedures have been actually adopted by these courts, most of them, they have put it that it has been adopted, significantly. That is about, I put in terms of numbers, precisely between 70 to 80, more or less. That these courts even actually follow to that extent these other procedures. Of course, in 2022. CRPC, now the BNSS, was actually made applicable to the whole state of Meghalaya for the first time, okay? But there is in that notification for application of BNSS to the state of Meghalaya, there is a para which precisely says that the district council courts shall continue to derive powers under paragraphs 4, supposed to be 5, sorry, of the 6th schedule of the Constitution of India. Meaning that, of course, that aspect of that this court for these courts under the 6th schedule should follow their own procedures is still, of course, valid.
Professor, last 2 minutes.
Just 2 minutes. Okay, thank you. Quickly, I'll just highlight you about this case. I mentioned that a decision where the district council courts basically had to deal with a situation where relating to the grant of successions. So it was here the petitioner and Mr. X basically got married in the year 1988 or 87, and it was basically the marriage that was solemnized. Then during the lifetime of Mr. X, during the subsistence of his first marriage, he married a second wife, and in fact, married here, in fact, I have highlighted the word cohabited. So they cohabited and lived together and had children, and in fact, he died in 2017 while staying with the second wife. Now, the dilemma before the court, of course, was that when the suit was filed for the grant of succession certificate, of course, the petitioner, the first wife, claimed, of course, she's the rightful heir. The respondent, on the other hand, as well, claimed that she was, the rightful heir because that her late husband died. She was the one who was taking care of him, and that, of course, that he lived with after he separated from the first wife. He had been living with her throughout till his death. Okay, so therefore, basically, issues of frame, I have touched on just 3, whether the petitioner is the wife of the deceased, talking about Mr. X here, with whom did the deceased live, that is Mr. X, and cohabited together as husband and wife at the time of his death? If so, who bore the expenditure for performing the last rites of his dead body? Who is legally entitled? Now the question is, who is legally entitled to inherit the debts and securities left behind by the deceased? Now, of course, here, the fact that, okay, the petitioner was declared, yes, she's the legally wedded wife because the marriage was never dissolved. To the second question here, of course, also the court answered in favor of the respondent that she was the one with whom Mr. X, the deceased, lived. Okay, so therefore, the answer to the third question now. Okay, who should be actually the one, the rightful legal heir to this. So just to mention that in the in the Khasi society to which I belong to, it's very common. It's like a customary law and practices that somehow when a couple they live together, they cohabited, they are actually recognized as husband and wife, though officially it was never solemnized. So it's not a live-in relationship as we would say, but it has been always recognized as actually as a marriage. When they themselves they would acknowledge to the relatives that we have to live as husband and wife. Anyway, the point is here. Then the court said that of course both of them they are entitled to inheritance, to succeed to the debts and securities left behind by the deceased. For the second wife, of course, the court had mentioned the fact that okay, she is entitled based on customary law, customary practices. Okay, so in that sense, and okay, it may appear to be like a conflict of, let's say, in the context of state law to say, okay, if you go strictly, only the first wife is the legally wedded wife, is the one who should be inheriting everything. But somehow the court has actually invoked customary law practices to say that even the second wife, even the respondent was actually a wife. So in that sense, they were equally entitled to inherit the property. Anyway, I think that I'm already overshot.
Yeah. Thank you very much for your presentation. So the paper looked at an instance of legal pluralism when it comes to understanding the Khasi identity, and